Well, welcome again. Many of you are already have already entered the webinar. Destination Italy, new tax resident, flat tax regime, new tax guidelines, and the Bel Paese. It's Italy, the beautiful picture. I'm sure you recognize Italy. As you know, our firm is quite relevant on the issues of mobility and relocation and trust. And we take benefit of this webinar among us, as we believe that it is useful to have a discussion among Valerio Vallefuoco, Andrea Moia, Domenico Sanicano, Luca Luoni, which we'll later introduce, in order to give you not only a flavor, but our gut feeling of this very good circular newsletter from the tax authority about trust and taxation, which insert very well within the environment of the legal and tax relocation in Italy. And we are actually having a lot of attention, although we tend to say that the trust is just a tool and Italy is a good place to move, but it's not the only place. So as you know, we would like to have a very broad view. And we have basically produced, and all you are attending already received what we call Destination Italy, because we launched an Italia desk, in particular at the London office, the Swiss office, which of course take benefit of our Italian firms. And on this, you can find in our email, but you receive this publication, which focus a lot on immigration, relocation, the regimes for the flat tax, the new tax res, as we call, the pension regime, the impatriati regime, the investor visa. So we will not enter today on how these programs works, because either you know, and I'm sure that a lot of you already know, or you can have full benefit on our Destination Italy publication. But we will focus a little bit more with a couple of examples on actual opportunities in full compliance, both regulatory and in terms of tax, on the use and combination of these. So the first of our speaker is Professor Andrea Moia. He's a teacher of international law at the Luke University in Milan. And Andrea, welcome, and to you, the Italian understanding on trust, please.
Okay. Good evening to all. Thank you very much. As you know, trust are fully admitted in the Italian legal system. Italy was the first country, civil law country, that fully rectified the Hague Convention in 1996, no? And from 1992, we can say that it's fully recognized in our country. Is it possible now to set up domestic and international trust with several advantages in terms of succession planning, asset protection planning, and also under certain conditions can be an interesting tax planning tool. On 20 October 2022, the Italian Tax Authority finally released an update regarding the general guideline about the Italian regime of trust. It should be noted that in any case, the Italian circular is not the law. No, is a specific indication about the practice, the guideline of practice that any taxman, tax officer will follow in case of any tax control. No? So the law is different. No? Under our legal system, the law is compulsory. Of course, the case law is very important. But the circular gives the guideline for the application by the administration about the taxation of trust. The guidance set out the direct and indirect taxation rules. And regarding direct taxation, it's very interesting to understand that there is a clarification regarding the taxation of income distribution from opaque trust established in low tax jurisdiction to Italian resident beneficiary. The tax authority viewed that such distribution should be qualified as capital income and shall be subject to taxation in the hands of the beneficiaries upon distribution. The distribution from opaque trust established in jurisdiction regarding as low tax continue to be exempt from taxation. A key point is what is the meaning of the concept of low tax jurisdiction? We have low tax jurisdiction when there is a nominal taxation level of the trust lower than 50% of the applicable rate in Italy. So now for any estate and succession planning project, we need to understand before if we have to set up a trust in a low tax jurisdiction or not, in order to do a proper planning and understand which are the advantage of one solution on another solution, because we can have alternative solutions that are quite interesting. The nominal level of the taxation shall be compared when the income is realized by the trust, no, with the relevant corporate tax rate in force in that time. An important additional clarification is relative to the presumption that the distribution by foreign opaque trust to beneficiaries in Italy is considered to be income only if it's not possible to separate income and capital. And these rules is applicable only to opaque trust established in low tax jurisdiction. So you can, of course, beat this presumption, showing the distinction between income and a capital. For this reason, it is important to organize that each trustee organize a specific accounting system in order to separate income and capital under the Italian rules. Of course, if there are Italian beneficiaries or Italian potentially foreign beneficiary with fiscal residency in Italy. Regarding indirect taxation, the big and interesting news is that finally any transfer to a trust is subject to a registration tax of only 200 euro. The taxation is absolutely fixed, not anymore 4% like in the past. So under this interpretation, no, that follow the Supreme Court 120 Supreme Court judgment, finally the Italian tax authority apply the rules of the preeminent case law, that is the position of the Italian Supreme Court. So finally, in the future, we will not have to discuss about the contribution, the assignment, and the taxation of the assignment with the tax authority, because now taxation is virtually zero with a registration tax of 200 euro. So a lot of opportunity in the field of real estate and reorganization of asset with important valuation. Tax authority also confirmed that if the inheritance and gift tax were already applied at the time of the settlement of the asset, no further tax will be due at the time any transfer to the beneficiary. So what is really important under this circular is to understand which are the new rules and made an important checkup of the most important rules related to any trust deed in order to have a new drafting of each trust in line with the new guideline of the circular. Which are the most important clauses? First, the clauses about beneficiaries. Second, the clauses on the accounting system of each trust. And finally, also some drafting related to the trustee powers, because powers of appointment, powers to change beneficiaries that need to be carefully reviewed. Thank you very much.
Thank you, Andrea. And in particular, the circular newsletter will be interesting enough to understand whether it has been already paid in the past. So it's quite important to make an assessment to existing trust. If I would be a trustee, I would ask a qualified professional to check and see whether in the meaning of the Italian circular newsletter, the trust can oppose the fact that already paid taxes at the beginning in the past will be considered paid for the future payments, which is something which we call a serious trust checkup we need to perform. Well, I move on discussing about this item of the circular newsletter, which is actually quite relevant, and we have no interest on entering on everything. We have sent to you, and you can find on our website, our opinion is 15 pages from us on 60 pages from the tax authority. What is actually very relevant is what is at a glance. There is a new meaning of discretionary trust. You are all friends or feeder or client of our firm, foreign lawyers, not Italian lawyer, I mean, and be careful because we have now a meaning of discretionary trust from the tax authorities in Italy. So the discretionary trust they have in their heads, it's not the discretionary trust according to English law or according to any other law applicable for the trust. As you know, through the Hague Convention, we can use many laws. So it is like a double track. One thing is the juridical situation, and one thing is the tax. And the discretionary trust is a definition which is punctually made at page 6 of the circular newsletter. This is the same for income tax. It's quite relevant to understand that there is the meaning of stability, which stability means established, but for the tax authority means where the tax is resident. As you know, in Italy, we have this very odd concept that the trust itself is a tax entity. So it has a fiscal code, it pays taxes, it has its tax return. Well, in this case, it is important to understand if the trust is commercial, really commercial, non-commercial, really commercial, and then if it is resident, non-resident, opaque, transparent, with some effects on the income of the trust. And again, if it is opaque, if it is established in low tax jurisdiction, like Andrea explained before. Again, in the indirect taxation, as we will see in our example later on, it's quite important to understand that there is a program. So something enter the trust and pay 200 euro, stamp duty fee fixed, and then when and if it will get out, he will pay taxes, but according to the relationship between the father and the beneficiaries, so there are a lot of items to be checked. And again, there are a lot of Italian tax monitoring obligation. If the beneficiary of a trust is resident, of a foreign trust is resident in Italy, there are some clever things to understand, like, are you a discretionary trust within the meaning of the tax authorities? Yes, no, and therefore, which obligation are upon the beneficiaries? Which again, with the privacy concept. And then, last but not least, there is a necessity to have an accurate bookkeeping of capital and income, but again, not according to the English meaning of capital and income distinction, but according to Italian tax rules. The example, I'm sure, will explain more. So on a cross-border, and then I leave to my colleagues, on a cross-border structure, it is very important to see when and where, in which jurisdiction was tax resident the settler, when and where are the beneficiaries. The settler, important thing for the tax authority is when he settled things, assets. So it was non-resident, it will stay non-resident even if he moved to Italy. On the other side, we have to check and see whether the assets are in Italy or the assets are out of Italy. And so there are some interesting and convenient check and balance to understand for the trustees, for the beneficiary, which in our view make the necessity of a serious checkup on existing structures, and on the other side, make wise trust planning applicable for new and convenient estate planning. So moving on to my colleagues, I like to introduce Valerio Vallefuoco, and Valerio is a founding partner of a firm founded by his father, but is in strong alliance with our firm. He's an expert of anti-money laundering and CRS issues. Please, Valerio.
Good evening. I'm Valerio Vallefuoco. I'm the partner of Rome, of Belluzzo International Partner. And I have more than 20 years of experience on the field of anti-money laundering, taxation, and international competition, which has made that some appointment to teach as a school of academic of the Italian economic financial policy, Guardia di Finanza. And most recently, I had the honor to teaching of the OECD School of Economics Financial Policy, where I held a course to American FBI, British IRS, and Canadian Financial Policy about the procedures and the sanction of the European Union on anti-money laundering. Today, in Italy, also in the European Union, the tax compliance is inextricably linked to the anti-money laundering legislation. And the European criminal law also considered a tax offense, considered as a such of taxpayers' country of residence to be predicated offense of the offense of the anti-money laundering. One of the examples of tax compliance applied to the anti-money laundering legislation is probably the recent circular of the Italian IRS about the tax treatment of the trust in Italy. As there is a part that talking about the tax monitoring obligation that is very linked to the definition of the beneficial owner of anti-money laundering law in Italy and in Europe. We have a link from the Article 4 of the decree number 177 of the 1999, like the last version, that say that the beneficial owner of the investment in accordance with the Article 1 of the legislative decree 231 of the November 206, that there is the anti-money laundering law. And as a result of the last amendment of the 2017, the beneficial owner of the investment about the last version of the 5 directories and in substantially the definition of the beneficial owner is the natural person or person other than the customer in whose interest or on whose behalf to continue the relationship in ultimately established. The professional service is rendered to the transaction ultimately carried out. So there is a very strict link between anti-money laundering law and tax law. Another criteria is the person who where the application of the criteria when there is other person, for example, as a beneficial owner, the founder when alive, the beneficiaries when identified or easily identifiable, or the holder of the powers of legal representation, management, and administration. So there is also a very strict link between the anti-money laundering and the tax compliance. The most important goal of this circular is to give us, to the Italian taxpayer, the correct individuation of the tax compliance. So now it's important that the trust and trustee doesn't follow our compliance. The financial institution must done as SAR. We have a document the 2013 that is from the Financial Intelligence Unit of Italy, that is the representative scheme of abnormal behavior within the meaning of the Article 6 about the operation related to abnormal use of trust. These are interesting documents that we can send it, and there is many bullet point and abnormal use, abnormal habits that you can find. And normally, if you are not compliant with the tax, there will be a SAR. Last but not the least, as you know, in European Union, there was a very interesting decision of the Court of Justice of the European Union about our UBO register. As you know, in Europe, there is all the countries are obliged to have a business register about the beneficial owner. But the last decision of the European Court of Justice on the 22nd of November 2021 stated that the article of Directive Anti-Money Laundering about the prevention of use of financial system of money laundering, terrorist financings, and amended the directive about in the part that was amended that provided the member must ensure that the information of the beneficial ownership and companies and other legal entities within their territory is accessible in all cases to any member of the general public is now against the European law and European about the Charter of Fundamental Rights of the European law. So now the implication of this decision, also in Italy, but also in Malta, also in Luxembourg, and the other countries of the European Union, about this judgment that has an effect of invalidating the relevant part of the mentioned directive. Now the UBO register limiting the access of the register of a beneficial owner to the competent authority only about and at the subject person only. For the other person, they must be registered and have an authorization to reach this information. So thanks a lot for your attention.
What is very interesting is that if, as Andrea Moya said, legal-wise, we have a complete understanding, the Italian authorities have a complete understanding of the trust. Tax-wise, we have these guidelines, and now also for anti-money laundering, UBO register, and in general CRS. Actually, there is a great comprehension of the use of trust, which makes Italy a friendly jurisdiction if you behave properly and if you stay in the path of compliance. Now we move to a different section of our webinar, which is about some example. And I'll start with Domenico. As Valerio said, he's our Rome office. Andrea in our Milan office, and Domenico is in our Milan office. Domenico has a great experience also because his past life, he was on the other side and for a long time. And please, Domenico, it's your turn for your example.
Thank you, Luigi, for your introduction, and thank you to our friends that are attending this meeting and for sharing their time with us today. I'm going to talk about two very important provisions state in Italy, both introduced with the 2017 budget law in Italy, namely the new tax resident regime and the investor visa, the new investor visa, so the so-called golden visa. We are moving in two different arenas. The first one, with investor visa, we are moving in the immigration law framework. This kind of visa is a new kind of visa, new type of visa for foreign citizens who intend to make an investment in Italy, or donation, of course. Just to underline that in general, the annual quotas, entry quotas are defined with a special degree. With investor visa, all individuals that would like to apply with this regime are independent of these quotas and degree relevant. With the investor visa to the applicant, repeat, the applicant is a national coming from countries that are not member of EU or within the Schengen area, countries, of course, is linked to the investor resident permit. The investor resident permit is a new resident permit valid for 2 years in the first instance, but it's possible to renew it for other 3 years, and that issued to the visa holder after they arrive in Italy. The procedure is completely online procedure. There is a dedicated portal. Every applicant has to open a personal account. The procedure is split in 3 steps mainly. The first step is the request of the visa. It's set aside the collection of the document, and mainly it is managed by the investor visa committee. Another important role is vested by the consulate where the applicant is resident, Italian consulate in the country where the applicant is resident. Once release the visa, that of course is issued by the consulate, the investor coming in Italy could apply for the resident permit. The resident permit is very important, and the condition for issuing the maintenance of the resident permit are only 2: the execution of the investment, and the maintenance of such investments. Only to give you a very, very brief report on the investment allowed. 2 million in Italian governative bonds, 1 million in philanthropic project, culture, immigration, music, 500,000 invested in Italian company, listed or not, 250,000 of euro, of course, in an innovative startup. The list of innovative startup, there is a list about 10,000 startups are listed in the company register dedicated area. Of course, in our experience, all our clients choose to invest, of course, in a blue chip, in an Italian listed company, bank, insurance, multinational, very large corporate companies. Of course, after the end of the second renewal of the resident permit, so after 5 years, it's possible for the applicant to apply for the long-term resident permit. But of course, if we cannot, it's only an option, they can also restart for the renewal of the visa. Let's move to the second very important provision. Also this has been introduced in the 2017, but in this case, we are moving in the tax arena. So let me say, the new tax resident regime. With this regime, it's allowed to individuals that moving their residence to Italy, so Italian citizenship and non-Italian citizenship, to pay a substitute taxation equal to 100,000 euro for each year for a maximum of 15 years. Of course, the condition to be met, set aside that the transfer of resident to Italy is to not have been resident for tax purposes in Italy in the 9 out of 10 tax year. Of course, the regime could be extended to the family member. In this case, the family member have to pay only 25,000 euros for each year. Same timelines, 15 years of extension. Very important from my point of view, two concepts. The full privacy is granted because the applicant is not required to report in the tax return that is mandatory to fill their asset held abroad, because we know that the substitute tax cover all income asset arising from asset held abroad. At the same time, there is no any remittance rules or remittance bonds issue. This means that the individuals has not need to change their wealth structure, for example. No wealth tax on the asset held abroad, no gift and inheritance tax to asset held abroad. The only exception of this point is regarding only for the sale of the qualified participation in the first 5 years of validity of the option. What does mean qualified participation? In a listed company means 2% of the voting right or 5% regardless of voting right. In the not listed company means 20% of the voting right or 25% regarding its voting right. Of course, there is for the exact calculation of this percentage of the selling of the share, there is the circular issued in the 24, the number 14, or 4, issued in 24, that explain very well that in order to understand the percentage of the selling, we need to take in accounting the 12 months within this space and the selling. Important point for me is the exercising of the option, not by tax return, of course, is the main option. It's not an option, it's mandatory, by the tax ruling. Why with the tax ruling? Because the tax ruling is the only way, not only for discussing with the Italian tax revenue, the tax administration, but also to collect a written response, formal written response to the possibility to access to the regime. And I would like to underline this because there are public ruling on this point, but there is the possibility with the tax authority to manage the point regarding the selling of the qualified participation within the first 5 years of the option. Of course, after the 5 years, the application of the substitute taxation covers the Italian taxation.
Very well, thank you very much, Domenico. Of course, everybody, I would say, knows about the new tax regime, which is now quite popular. In our firm, we work not only with Italian or UK regimes, but also with Portuguese, Greek, the new Spanish, of course, through correspondence and some friends that we also are attending here. And basically, it's quite important because it's all through movement of capital and mobility and of people. And therefore, our immigration department, is particularly in Milan, is quite engaged on this procedure with Italy. Not only. I'd like to present you what we can say maybe sophisticated example. It's just one slide, but it's quite deep. The new tax guideline about trust and the new tax resident regime can conveniently work together. We had in the past, and to me, the result of 3 firms has some rulings about that. we had in the past already information and allowance, let's say, of the use of trust and new tax resident. This example is quite complex, the slide, but I try to simplify. Let's imagine one husband, one wife, they come back, they come to Italy, okay, they have a European passport, no need for investor visa. He paid 100,000 she pays 25 for the flat tax regime. And they have one son, which follow the family, but instead of entering the new tax resident regime, they enter the repatriated worker regime. As you know, it's again an optional regime, which cut 70% in the north, 90% in the south of the income rate for, in example, employees' income. So in this case, we have the whole foreign family moving to Italy. But before moving to Italy, Mr. Settler, Mr. Husband, set up a trust, or maybe he already has a trustee. When I say a trust, remember that for Italy, the trust is a tax entity. So the trust itself is the taxpayer. So the trust, in example, regulated by Jersey law, we can set up structuring with our colleagues, trust with retained powers. Which kind of retained powers? As many as you like, as far as you don't arrive to a sham trust according to the local jurisdiction. Why? Because if the husband settler pay 100,000 and set up the trust, all assets out of Italy are within this broad concept, a trust and estate planning, where because of CRS, we have privacy, because of the trust UBO register and the ECJ decision, we have privacy. Of course, it's full compliant, and if authority needs, we open, but it's full compliant. And all income the trust makes offshore from Italy are included in the 100K tax optional flat tax regime. So this is something that is quite, now, I don't want to say popular, but and it's a very broad example full of details, as you clearly understand. But I would like to underline that the new tax regime with the foreign trust after the circular newsletter, in particular if it is a discretionary, because the idea of the Italian discretionary definition from the tax authority is a discretionary trust is also when the settlers say, I will decide in the future who is a beneficiary, which is not actually a discretionary concept within English law, but it is within the circular newsletter. So, in example, if then they move out after 5 years because they go back to UK, or after 6 years because they want to go in another place, and the son stay in Italy, the son, if it is a discretionary trust, has not to report in the fiscal for the fiscal monitoring obligation. So it's quite interesting to combine the concept of new tax resident, of a family office in other countries outside of Italy. A small SPV would be sufficient, and a trust, international trust, with regulated by a foreign law, but according to the Hague Convention, fully legal in Italy, and according to our tax authority guidelines with retained powers, which could be very, very relevant. It's kind of unique composition, which I see it's taking great interest within the firm we are now, and the banks we are now visiting around Europe and the world. I'm sure that because already a couple of questions arrived in my BB, in my WhatsApp, but we will follow up on this. I just wanted to show how interesting it is to combine different opportunities that the Italian jurisdiction allows you to have and to give. So I now would like to pass the ball to Luca Luoni, who is our responsible from the Lugano office. Luca, the floor is yours.
Okay, thank you so much, Luigi, and thank you to everybody for being here tonight. So I'd like to take stock of the topic that has been assigned to me, that is the international trust with Italian assets. And also in this case, the trust could be a suitable tool for foreign individuals willing to invest in Italian properties. So we may have two different situations depending on where the settler is tax liable. The first option is when a settler is already tax resident in Italy. And the second option is when the settler is not yet an Italian tax dweller. However, as we may better see in the following, both options above don't change the substantial effects of the structure. But in the case of a settler not tax resident yet in Italy, and if it contributes cash to the trust itself works even better because of the benefit of no gift tax at the moment of the distribution. So the hypothesis we are now treating, as per the slide that you are looking right now, is for a settler that proceeds with a cash contribution into a discretionary and irrevocable trust based in Luxembourg. We have already heard from my colleague that based in Luxembourg means, according to the praxis, stabilito. That means that is the place where the trust is actually taxed. So, notwithstanding Luxembourg is an EU member, according to the recent Italian praxis document, as the trust assets are in Italy and there are taxed, the trust itself is treated as a domestic trust. So, as per the new rules introduced by the document that we are looking at right now, the initial contribution in cash to the trust is not subject to the gift tax. That, as we may see in the following, is due only upon the final transfer to the beneficiaries, as Andrea already highlighted in before. So the only tax to be paid is the registration tax for €200, and no other individual income taxes are due. So once the trustee receives the money, he shall purchase a property in Italy that shall be rented out or left available. Then, during the life of the trust, the income retrieved by the property shall be taxed at 24% as per the corporate tax rules that apply according to the Italian laws to the trust. And the taxable amount shall be or the lease incomes if the property is rented out, or the figurative income if not. But in both cases, we are sure that applies the 24% corporate tax provided by the law. Taxable, if the property is sold to potential capital gain, and that is very important, the capital gain is not taxed, because if the property has been held for more than 5 years, according to the Italian law, as said, the capital gain is not tax liable. Then, further to the sale of the property, the price shall be or reinvested or distributed to the beneficiaries. In this last case, we should, as we have already seen before, we should separately treat what is deemed as a capital, so the initial cash contribution from the settler to the trust, and what is deemed as a gain. The initial capital shall be transferred to the beneficiaries upon the payment of the Italian gift inheritance tax according to the family relations with the settler, just in order to benefit from favorable percentages and exemptions. And the gain, on the other hand, won't be taxed anymore, and this is very important, as the capital gain tax has been already settled, even if only virtually, whether the property, as said, has been sold after 5 years from the purchase. This would mean that an accurate account, as Luigi already said, of the trust is always required, and not only for the so-called paradisiac trust. We strongly suggest that a thorough accounting of the financial movements of the trust are absolutely due. And lastly, whatever the property is not sold, it shall be transferred to the beneficiaries upon the payment of a gift tax based on the cadastral value of the property, which is usually much lower than the relevant market value. And the further taxes to be paid are the cadastral and mortgage taxes at the rate of 3% on the cadastral value, or even a fixed fee of only €100 if the property shall be deemed as a primary home. So as you may see, the trust structure for the purchase of properties in Italy works perfectly and provide the investor with very, very interesting benefits. So thank you very much.
Thank you very much to you, Luca. And what is interesting is that this is just an example that it's of course a little bit sophisticated on a cross-border perception, but we wanted to share with you because we know you, and basically it's not a scheme. It is like a correct interpretation of the tax guidelines, which make a serious new runner within the estate planning, because if somebody moves to Italy, there is a serious convenience to purchase a house before moving to Italy through an international treasury trust, in example, in Luxembourg. And this is something we can, of course, work on, but this is just an example, and we will have many more in the future, I hope. Now it's time of Alessandro that I see collected, which is going to talk for UK and Italy a cross-border perspective. As you know, we have office in London, we have Italian desk and Luxembourg desk and other desks everywhere in our offices in the firm. But what is very important is that we have experience on many British people and also Eastern European and Latin American moving to Italy. So it's an interesting case to hear Alessandro, who is a barrister in London. To you, Alessandro.
Good evening, everyone. I'm going to talk about a UK perspective to start. Listening to and having so many experienced cases lately of people like moving from the UK to Italy in this instance, I thought was important to start by giving you a brief update of the last autumn statement that everybody probably knows hasn't been very well received for different reasons, because the taxation went up. And so people are even more concerned now about the future of the UK being an attractive country for residency purposes, tax special situation in terms of the attraction of the UK that was before. The fact is that what we were and most really concerned about was a possible change on the regime of the non-dom, which has been, to our knowledge, just postponed. But if you can see in my last point of the slide, there's been, in fact, a measure about the non-doms, which is quite peculiar and very, very sophisticated measure, because I don't have time now to go through this in particular, but it has an immediate effect. It targets reorganization of non-domiciliaries using vehicle offshores. And so this is something, if you wish to know more, would be very happy to have a separate conversation about. But this is a testimony of the fact that, unfortunately, at the moment in the UK, the narrative has changed. And so many people are thinking of leaving, not just because of Brexit, but because of the possible tax changes. At the moment, for the time being, res non-dom rules are still available up to 7 years for free, from 7 to 12, 30K. Remittance charge is due, from 12 to 15 is 60K, the charge that is due. So it's still attractive to the UK, of course, yes. But what has changed mainly from the perspective of many of our clients is that the UK is no longer a European country in terms of the Brexit occurrence. So everybody that wished to enter the UK now requires a visa. I'm not going to talk about now in details, but as you know, this is a big difference that before that you could come to the UK as a simple European citizen and get residency quite easily in the UK. At the moment, you require a visa and a system that is very similar for what was for non-European citizen in the past. So what we're seeing now, we're seeing also people thinking and considering entering the UK, of course, and having to face this new burden of the visa, and they wish to enter, they need to be aware of the rules that, to me, if you can move slide, please, the big change of the rules, they're starting really in 2013, 2014, 2015, when many things have changed in terms of what we consider a person to be resident, so the statutory resident test, applicable to leaver or arriver, so meaning person that comes to the UK or goes from the UK to Italy, for instance, and is the attitude as well of the HMRC that has changed a lot. So careful consideration should be taken, and of course, an advice should be taken before you decide whether to reside in the UK or leave the UK. Let's take the example of you wishing to leave the UK because of what we heard before. Let's say that Italy became quite an attractive country for the time being, for many reasons, including La Dolce Vita, of course. You can try to become resident in Italy. And again, because of Brexit, if you were to come from UK, you will face the same situation as people going to the UK. So you require a visa, first of all. And then secondly, you have to choose which regime you want to take in Italy. This has been explained by my colleagues before. But what you have to be very careful, what we're trying to be really different here, is that we need to tell you that the main issues are not only in Italy, but are also in the UK, in what we call the cross-border and potential issues and remedies that are available to you. In particular, what is important, apart from the UK resident test that is still applicable for a leaver, is important that you know about the resident test in Italy. Again, I will not go into details now, but then what is most important is that you should be aware of the Italian dual tax treaty with the UK, which of course is applicable under Article 4 to determine who is residency and where you are a resident for tax purposes. And what we are seeing at the moment is that there are many cases of people that wish to leave the UK, go to Italy, apply for the flat tax regime, for instance, in Italy, where is a very good regime because there are many good reasons. But one is very important in this regime is that it's still possible to apply the treaty when you're using the flat tax regime, and which is a very important point when you think about planning for your residency. But when it's very important as well to see and check if you wish to come to Italy and to become resident in Italy, is that you don't forget the rules in the UK. The rules in the UK, as such, the resident test, the rules in the UK for estate planning, as such, for inheritance tax purposes, and where your family will still reside, where you wish to reside, where your assets are. So our approach is that you think about your asset, you map your asset together with professional help, and then you decide how to plan in advance, because you can find yourself in a situation very similar to one of these cases that we are following at the moment, in particular, one of these person that is Italian and the other one is South African. And there is a case now that we just won in court that has been very, very important case about the application of the treaty between, in this case, South Africa and the UK, which is very similar to the UK and Italy, whereabout the South African citizen was able to spend more days under the treaty than what would be the case under the state resident test. So to say the least, because we don't have much time, I think it's very important to know now that you can well decide to reside in Italy. You can well know about the rules in the UK, but you can well rely on the treaty between, in this case, Italy and the UK, to be sure not to be resident in the UK still. And this is a very important breakthrough. And I would suggest to you and to any of your consultants that you require to consider this point very carefully, because it's very important that you look at the two situations together with professionals that are aware about the two regimes. And sometimes there is a better solution when you apply the cross-border structuring. So that's my final point. And of course, I remain available for your questions. Thank you very much.
Thank you, Alessandro. And the example of this slide, just to conclude, the speech is quite irrelevant because it's actually a real case where, as you can see, there is a couple. In July 2022, we have done the assessment phase with the lawyers of the one lawyer for the wife, one lawyer for the man. And in September, we structured this combined UK resident analysis. We identified ties for the living, and we, of course, worked together with the London office and the Milan office and the lawyers of the couple in order to understand, because as you can see, the plan is now the final drafting has been already submitted, isn't it, Domenico? You are looking for that. And response will be available in 120 days average. And in April 2023, because Italy followed the calendar year, the UK, as you know, follow the year from 5 of April, the actual transfer of Italy will arrive, because on the split year, there is a difference of perception between the UK and Italy. And in May 2023, there will be the civil relocation. And the couple will be able to work and live in Italy and in the UK as far as they will count days, as we can see now. So basically, the full idea of this webinar is to pass the concept that Italy as a jurisdiction is quite attractive. We have presented you our destination Italy. We have all information about immigration, visas, relocation, special regime, how to buy a real estate. The trust understanding from the tax authority is very relevant, and we have really a growth in a common understanding with the tax authority about trust structuring after the voluntary disclosures in the last 7 years and on. It is quite important to be clean and fresh in the structure, also if you are very sophisticated. And I'm sure that we will have the possibility to work together in the future. Now is December, everybody is in the rush, but this is something Italy as a bel paese or the Dolce Vita, the relocation, the fact that we can have a hub in Lugano to work with international clients and their advisors, at the same time to work together in terms of possibility to make a proper estate planning in a proper environment. As promised, it was only 60 minutes. This will be recorded and mailed to you and to the other people who asked to attend but could not at this time. And I thank you very much, all my colleagues, for the proficiency and their work. And at the same time, I thank you for attending this webinar. Bye-bye.